Good morning everybody. In the previous video, we discussed about national highway alignments. Now let us discuss on the compensation part for land acquisition. First is 3A notification is published, and then 3D notification of declaration of acquisition is published, and then the competent authority passes 3G award determining the compensation. If the land losers accept, it will be paid to them, otherwise it will be kept deposited with the land acquisition authority. If the compensation is not agreeable, people may go in arbitration under section 3G subsection 5. The land acquisition authority, namely the KALA, competent authority for land acquisition, will determine the quantum of compensation to be paid to the land losers. Apart from that, under Article 3G subsection 2, the NHAI has to pay 10% over and above the compensation for loss of easement rights, which are vested in the owners also. We know easements rights arise on account of continuous usage or by agreement, whereas the easements rights of the land owners are inherent. So this 10% must be paid to those persons who are the land owners or who have easement rights over the land. The competent authority or the arbitrator have to consider the market value of the land and the loss arising out of acquisition of the land to other properties of the land owner, or loss arising out of separating the acquired land from other part of the land. And in case of residential property, of course, the shifting charges also will be considered. Under section 3H of National Highways Act 1956, the central government has to deposit the compensation monies with the KALA, and in turn the KALA will distribute it among the various landowners. Supposing there are disputes as regards the shares of joint owners, such dispute shall be referred by the KALA to the principal civil judge of that district. When the arbitrator under section 3G clause 5 enhances the compensation awarded by the KALA, the arbitrator shall also allow interest at the rate of 9% on the enhanced amount from the date of 3A notification till it is actually paid, and the arbitrator shall cause to be deposited the enhanced compensation and interest with the KALA. The whole problem in payment of compensation to the land losers under national highways is that under section 26 of the Fair Compensation Act 2013, the KALA will adopt the sub-registrar value as the market value. To that, he has to add the multiplying factor. Usually the multiplying factor is between 1 and 2 in case of rural areas, and it is 1 in urban areas. So arbitrarily sometimes the KALA is adopting 1.5 times for rural areas, and in fact multiplying factor of 2 should be applied. When it is said between 1 and 2, since this being a beneficial enactment, you should always be interpreted in favor of the land loser, the beneficiary. To determine the SRO value, the higher values for which the lands were registered either by way of sale deeds or agreements, the higher value documents are taken and average considered for the last 3 years. So half of the higher value documents are considered for averaging the price. Having taken the value of the sub-registrar, multiplying factor is applied. Supposing, to understand better, the sub-registrar value is 1. The multiplying factor is 1.5. So what the department is doing, 1 is multiplied with 1.5 to give a product of again 1.5. So if the registrar value is 1 lakh, its market value is calculated as 1.5 lakhs, and equal amount of solatium is awarded. Then 1.5 plus 1.5 is equal to 3. So the farmers are getting 3 times the sub-registrar value. This is a lopsided understanding of the provisions of law. Multiplying factor does not mean to find out the product. Multiplying factor is the growth factor, which is incremental, which is in addition to the SRO value. When SRO value is 1, if you want to apply multiplication factor of 1.5, then you have to arrive at the sum total of 1 and 1.5, which gives you 2.5. So equal amount of solatium is 2.5 times, and then the land loser will get 5 times the SRO value. This is true purport of section 26 and section 30. Unfortunately, the authorities are doing the other way. It is a great injustice to land losers. Under section 26 of Fair Compensation Act, subsection 2, that previously paid compensation quantums are irrelevant. Whatever may be written in a law book, but law must conform to justice and morality. How the previous compensation was not relevant for this may be challenged in a high court. Along with compensation, the competent authority for land acquisition gives 12% interest on the compensation amount from the date of notification till the date of actual disbursement or actual date of taking over of the possession of the property, whichever is earlier. But here again, there is a flaw. Under section 26 of the Right to Fair Compensation Act, the district collector is duty bound to revise and update the market values of lands as on the date of 3-year notification. In most of the cases, this is not being done by the district collectors. In such cases, we should insist on revising the rates. Otherwise, we have to claim interest at the rate of 12% not from the date of 3-year notification, but from the date of fixation of the amount of SRO value as existing as on today. That value might have been decided about 3 years back. So a land loser shall be entitled to claim interest from the last 3 years, earlier to 3-year notification. With this, we come to an end of our discussion regarding compensation for lands acquired under National Highways Act 1956. Thank you. Thank you for watching this video. I request you to please subscribe, share and comment on my videos, and in due course we will be discussing the entire constitution article by article, highlighting wherever it went wrong. Thank you.